International dispute settlement. The introductions to international dispute settlements, informal methods of dispute settlement, compulsory and binding dispute settlement, jurisdictions in international dispute settlement, methods of international arbitrations, international courts such as ICJ, conclusions, settlement of international disputes, informal means of dispute settlements, compulsory binding settlement, jurisdictions and admissibility in international tribunals, international arbitrations. In contrast to domestic legal systems, which have a hierarchy of tribunals culminating in a Supreme Court, international law lacks such a unified structure. The principle of state sovereignty means that no state is obliged to submit to the jurisdictions of an international tribunal without its explicit consent. Consequently, the international legal system is characterized by a decentralized collection of tribunals rather than an orderly hierarchy. The International Court of Justice, the ICJ, while influential, is not a Supreme Court or Court of Appeal. International disputes vary widely in terms of their durations and resolutions. Some are settled quickly through informal means, while others may persist unresolved for years. In some cases, it is more effective to manage disputes than to seek formal resolutions. There is no universal method for dispute settlement, and the approach adopted often depends on the nature of the dispute and the parties involved. The United Nations Charter, specifically Article 33, outlines peaceful means for disputes resolutions, including negotiations, mediation, conciliations, arbitrations, and judicial settlement. These methods can be classified as either voluntary or compulsory, depending on whether the parties are legally obligated to engage in a specific process. Negotiation is often the first step in resolving disputes. It allows parties to define the key issues and seek a resolutions without resorting to formal proceedings. These discussions are typically held in private to facilitate compromise. If negotiations become formal or public, positions may be hardened, making resolutions more difficult. Negotiation procedures are highly flexible and controlled by the disputing parties. However, once a third party becomes involved, the process may gain momentum, limiting the parties' control. Consequently, most disputes are resolved through bilateral negotiations, although formal methods such as arbitrations may be required for more complex cases. If negotiations succeed, the terms of the agreement must be recorded, which may involve amendments to existing treaties or unpublished memoranda of understanding (MOUs). MOUs, while not legally binding, may have legal consequences, as demonstrated in the US-UK user charges arbitration case. When direct negotiations fail, a third party may be involved in the settlement process. Mediations and conciliations are common methods where a neutral party facilitates discussions and proposes solutions. Although non-binding, these methods may help in reaching an amicable resolutions. Conciliation is often provided for in treaties such as the Vienna Conventions on the Law of Treaties 1969 and the United Nations Conventions on the Law of the Sea 1982. Compulsory binding settlement procedures are akin to a nuclear option. They act as deterrent, pressuring states to avoid unlawful actions due to the potential for international legal proceedings. However, states must consent to submit to a particular dispute resolutions method. Two primary characteristics define compulsory binding settlements. The first is an agreement to submit disputes to a third party, and the second is a binding decision rendered by that third party. Before a tribunal hears the merits of a case, it must establish jurisdictions and admissibility. Before a tribunal, jurisdiction refers to the legal competence of the tribunal, while admissibility concerns whether the claim can be heard. Even if a tribunal lacks jurisdictions, it does not imply the claim is not true. Jurisdictions depends on the consent of the disputing states. This principle, known as le compétent de la compétent, allows tribunals to determine their own jurisdictions. The methods for conferring jurisdiction vary and may include a compromissory clause in a treaty, a general dispute settlement treaty, or an ad hoc agreement. For example, in Lockerbie cases, Libya invoked the Montreal Conventions 1971 to bring claims against the United Kingdom and the United States before the International Court of Justice. Even if a tribunal has jurisdictions, the claim must be admissible. Common objections to admissibility include the absence of a legal interest or the failure to exhaust local remedies. States cannot bring international claims on behalf of their nationals unless all local remedies have been exhausted, as exemplified by the Interhandle case 1959. Arbitration involves submitting a dispute to one or more judges, known as arbitrators, chosen by the parties. The arbitrator's decisions, known as an award, is binding. Arbitration is commonly used in treaty disputes and is not necessarily less costly or complex than judicial settlement. However, parties have more control over the process, such as choosing the arbitrators and the language of the proceedings. The Permanent Court of Arbitrations (PCA), established by the Hague Conventions for the Pacific Settlement of International Disputes in 1899, provides a permanent facility for arbitrations. While not a court in the traditional sense, it offers a range of services to states and international organizations. The ICJ, or the International Court of Justice, is the principal judicial organ of the United Nations. It is a permanent body, always available to hear cases, and states do not have to contribute to its costs beyond their annual UN contributions. The ICJ statute is a part of the UN Charter, and all UN member states are parties to it. True, this does not mean they have consented to the ICJ's jurisdictions in every dispute. States can confer jurisdiction on the ICJ through various means, such as compromissory clauses, reciprocal declarations, or ad hoc agreements. For example, in the Nicaragua case, the ICJ asserted jurisdiction based on the Treaty of Friendship, Commerce, and Navigations between the United States and Nicaragua. States can confer jurisdiction on the ICJ through various means, such as compromissory clauses, reciprocal declarations, or ad hoc agreements. For example, in Nicaragua case, the ICJ asserted jurisdiction based on the Treaty of Friendship, Commerce, and Navigations. International dispute settlement is a complex process involving a variety of methods depending on the nature of the dispute and the parties involved, from informal negotiations to binding arbitrations and judicial settlement. The international legal system offers several avenues for states to resolve their differences. However, the absence of a unified legal structure and the principle of state sovereignty mean that the system remains decentralized and ad hoc. Mixed arbitral tribunals deal with disputes between a corporations or individual and foreign state. They allow claims to be brought directly to the tribunal without involving the state of nationality of the claimant. Iran United States Claims Tribunals, established by the Algiers Accords in 1981, The Iran United States Claims Tribunals deals with claims arising from 1979 to 1981 hostage crisis and expropriations of U.S. property by Iran. It applies public and private international law and follows the UNCTRA arbitration rules. United Nations Compensations Commissions. Following the Iraq conflict, the UN Compensations Commissions was established by Security Council Resolution 687 in 1991 to administer compensations for losses resulting from Iraq's invasions of Kuwait. It is a subsidiary body of the Security Council and operates in Geneva. The International Court of Justice, the ICJ, is the principal judicial organ of the United Nations. It has jurisdictions over disputes referred to by states and matters provided for in UN Charter or treaties. The ICJ can also give advisory opinions on legal questions. The compositions and jurisdiction. The ICJ consists of 15 judges elected for 9-year terms. Only states can be parties to cases before the ICJ, and its jurisdiction is based on the consent of the parties. The ICJ follows a detailed procedure involving written and oral pleadings. It can order provisional measures to protect the rights of the parties during the proceedings. ICJ judgments are binding only between the parties and in respect of that particular case. Compliance with judgment is generally high, although enforcement can be challenging. The ICJ can give advisory opinions at the request of United Nations organs or specialized agencies. These opinions are not binding but are influential in guiding international law and practice. In the realm of international law, the peaceful settlement of disputes between states is a fundamental principle. This principle is enshrined in Article 2.3 of United Nations Charter, which obliges all member states to settle their international disputes through peaceful means. The methods of international dispute. International law provides a range of dispute settlement methods which can be categorized into informal means and compulsory binding settlement. Negotiations and consultations are often the first step in resolving international disputes. These methods involve direct communications between the parties involved, allowing them to discuss their differences and attempt to reach mutually acceptable solutions. Many international treaties include provisions that require parties to engage in negotiations or consultations before resorting to more formal dispute settlement mechanisms. Conciliation is a more structured form of negotiation that involves a third party. The conciliator's role is to investigate the dispute and propose terms of settlement. While the conciliator's proposals are not binding, they can provide a basis for further negotiations between the parties. Several international instruments provide for conciliation procedures, including the Vienna Convention on the Law of Treaties, 1969, Annex on Conciliations, the UN Conventions on the Law of the Sea, 1982, and the OSCE Conventions on Conciliations and Arbitrations, 1992. Mediation involves a third party actively participating in a negotiation process, proposing solutions and attempting to reconcile the parties' positions. Good offices, on the other hand, involve a third party facilitating communication between the disputing parties without actively participating in the substantive discussions. Arbitration is a method of dispute settlement where the parties agree to submit their dispute to an impartial third party or tribunal for a binding decisions. The Permanent Court of Arbitration (PCA), established by the Hague Conventions for the Pacific Settlement of International Disputes of 1899 and 1907, provides framework for international arbitrations. The International Court of Justice, as the principal judicial organ of the UN, plays crucial role in settlement of international disputes. The ICJ was established in 1945 by UN Charter and is based in The Hague, Netherlands. Its statute is an integral part of the UN Charter, as stipulated in Article 92. The court comprises 15 judges elected by UN General Assembly and Security Council for 9-year terms. The compositions of the court is designed to represent the main legal systems of the world. The jurisdictions of the ICJ is founded on the consent of states. Article 36, Clause 1 of the ICJ statutes provides for plenary subject matter jurisdiction, meaning the court can deal with any questions of international law. However, for the court to exercise its jurisdictions in a specific case, the states involved must have consented to the court's jurisdictions. This consent can be given in several ways. One of them is compromissory clauses in treaties. Many international treaties include clauses that provide for the ICJ's jurisdictions, and in case of disputes arising from the interpretations or applications of the treaty. Examples include the optional protocols to the Vienna Conventions on Diplomatic and Consular Relations, compromis. The second one is the compromis, or special agreements. States may agree to submit a specific dispute to the ICJ through a special agreement or compromis. The third one is reciprocal declarations under Article 36, Clause 2 of the ICJ statutes. States can make declarations accepting the court's compulsory jurisdictions in relation to any other state accepting the same obligations. This is known as the optional clause systems. The principle of reciprocity applies to these declarations, meaning that a state can only invoke the court's jurisdictions against another state to the extent that both declarations coincide. Admissibility of claims. Even when the court has jurisdiction, it may decline to exercise it if the claim is inadmissible. Several grounds for inadmissibility have been developed through the court's jurisprudence, such as the very subject matter tests. In cases such as Monetary Goal and East Timor, the court has held that it cannot decide a dispute if this very subject matter of the decisions would concern the legal interests of a state not party to that particular proceedings. The second one is the local remedies rule. It's established in cases like certain phosphate lands in Nauru. Applicants must exhaust local remedies before bringing a claim to the ICJ, particularly in cases involving diplomatic protections. And also mootness and the lack of object. The court may decline to hear a case if the dispute has ceased to exist or if a judgment would have no practical effect. Applicable law. Article 38, Clause 1 of the ICJ statute outlines the sources of the law that the court shall apply. The first is international convention or treaties. The second one is international customs. The third one is general principles of law recognized by civilized nations. The third one is judicial decisions and teachings of a highly qualified publicist as subsidiary means. The court may also decide a case ex equo et bono if the parties agree. Advisory jurisdictions. In addition to its contentious jurisdiction, the ICJ has the power to give advisory opinions on legal questions at the request of authorized UN organs and specialized agencies, as per Article 96 of the UN Charter. The jurisprudence of the ICJ has significantly contributed to the development of international law. Some landmark cases include Mavromatis' Palestine concessions between Greece versus UK 1924. This case provided a classic definition of a dispute in international law, which means a disagreement on a point of law or fact, a conflict of legal views or interests between two persons. Its Southwest Africa cases between Ethiopia versus South Africa, Liberia versus South Africa, 1962. These cases further elaborated on the concept of dispute, emphasizing that the mere assertion by one party that a dispute exists is not sufficient to prove its existence. Case concerning questions of interpretations and applications of the 1971 Montreal Conventions arising from the aerial incident at Lockerbie. Libya versus UK, 1992. This case raised important questions about the relationship between ICJ and UN Security Council, particularly regarding the judicial review of Security Council decisions. Legrand case, Germany versus US, 2001. This case established that the ICJ's provisional measures under Article 41 of its statute are legally binding. Case concerning the applications of the Conventions on the Prevention and Punishment of the Crime of Genocide, Bosnia and Herzegovina versus Serbia and Montenegro, 2007. This case dealt with state responsibility for genocide and the interpretations of genocide conventions. Avena and other Mexican nationals, Mexico versus USA, 2004. This case reaffirmed the binding nature of the ICJ's provisional measures and addressed issues of consular rights under the Vienna Conventions on Consular Relations. Other relevant legal frameworks, such as the General Act for the Pacific Settlement of Disputes 1928, which was revised in 1949, the European Convention for the Peaceful Settlement of Dispute 1957, the UN Convention on the Law of the Sea 1982, which provides a comprehensive dispute settlement system, including the establishment of the International Tribunal for the Law of the Sea, ITLOS. Legal framework. The primary legal frameworks for international dispute settlement is United Nations Charter, which establishes the International Court of Justice as the principal judicial organ of the United Nations. The World Trade Organization's WTO dispute settlement understanding. This framework governs disputes between member states regarding trade-related issues. It provides a structured process for resolving trade disputes, including consultations, panels, and the appellate body. The WTO's dispute settlement system aims to ensure that member states comply with their trade obligations and that the global trading system operates smoothly. The International Center for Settlement of Investment Dispute, ICSID. This institution provides a forum for resolving disputes between states and foreign investors. ICSID offers a neutral and impartial platform for resolving investment disputes, promoting confidence in foreign investment and fostering economic development. The International Criminal Court, the ICC, this court prosecutes individuals for the most serious crimes of concerns to the international community, such as genocide, crimes against humanity, and war crimes. The ICC's jurisdiction is limited to individuals and it complements national criminal justice systems by holding individuals accountable for the most egregious crimes. Influential cases such as Nicaragua versus United States case 1986. This case involved a dispute between Nicaragua and the US over the latter's support for the Contras, a rebel group fighting against the Nicaraguan government. The ICJ ruled in favor of Nicaragua, finding that the United States had violated international law by supporting the Contras and by engaging in military activities in Nicaragua. This case established the principle that states cannot use force or support armed groups in another state without that state's consent. In Gabčíkovo-Nagymaros project case 1997, it involved a dispute between Hungary and Slovakia over the constructions of a dam on the Danube River. The ICJ ruled in favor of Slovakia, finding that Hungary had breached its obligations under the relevant treaty by unilaterally withdrawing from the project. This case highlighted the importance of treaty obligations and the consequences of breaching them. International dispute settlement is guided by some of the several principles, such as state sovereignty. States retain their sovereignty and are not subject to the jurisdiction of international courts unless they consented to it. This principle reflects the fundamental principle of states' autonomy in international law. Pacta sunt servanda. The principle requires states to comply with their treaty obligations. It is a cornerstone of international law, ensuring that states honor their commitments and that international agreements are respected. Good faith. States are expected to act in good faith in dealings with each other. This principle promotes cooperation and trust between states, fostering a more stable and predictable international order. And then equality of states. All states are equal before the international law. This principle ensures that all states, regardless of their size or power, are treated equally under international law. International dispute settlement plays a vital role in maintaining international order and resolving conflicts peacefully. It provides the framework for resolving disputes between states, individuals, and corporations, ensuring that international law is upheld and justice is served. It is a complex and evolving field. Challenges, opportunities emerge.